On October 25th, 1994, 5 Lexington police officers entered a home looking for an 18-year-old named Antonio Tony Sullivan. They found him hiding inside of a closet. Sullivan came out unarmed, and multiple later accounts say his hands were raised. A Lexington police sergeant pointed a loaded 9mm pistol in his direction and began manipulating the hammer. The gun fired. The bullet struck Tony Sullivan in the head. He died inside the home, and police called it an accident. A grand jury returned no indictment. Federal investigators reportedly reached the same conclusion. The officer left the department. The city eventually paid a wrongful death settlement, and most of the evidence that supposedly proves that this was merely an unfortunate mechanical accident has never been available for public inspection. No complete police investigation, no firearms examination, no internal affairs report, no autopsy file, no grand jury evidence, no FBI closing memorandum, and obviously no public explanation of the disciplinary charges Lexington police were reportedly preparing against the officer before he left the force. Tony Sullivan's death is officially closed, but that definitely does not mean that it was ever publicly explained. You're listening to WTF Lex, a production of OGM Podcast Network. Real events, real accountability, and real Lexington. Let's get it. In Kentucky, some stories never get finished. They linger unanswered, unresolved, and often forgotten. This is Buried in the Bluegrass, a true crime podcast from O'Gurg Media. Each episode will dive into cases from across the Commonwealth, focusing on documented facts and those pesky little unanswered questions. You may have noticed 2 intros. This is a special crossover of WTF Lex and Buried in the Bluegrass. 1 Lexington story, 1 Kentucky death investigation, and more than 30 years of unanswered questions. Welcome to WTF Lex, real events, real accountability, and real Lexington. And welcome to Buried in the Bluegrass, where we dig into Kentucky deaths, investigations, and the records officials would probably rather sometimes leave buried. And as always, I'm everybody's favorite, well, we're trying to keep it PG tonight, so I'm the one everybody loves to hate. I'm Old Gurg. Today we are examining the fatal shooting of Antonio Orlando Sullivan, better known as Tony Sullivan. This story involves a police shooting, a disputed eyewitness account, racial unrest, a grand jury decision, a federal civil rights investigation, a secret settlement, and an officer whose weapon supposedly malfunctioned at the exact moment an unarmed teenager was surrendering. We are going to separate what is documented from what is alleged. We are going to point out where the sources conflict and where the records do not exist or have never been made public. We are not going to pretend that an official conclusion fills those gaps, because it doesn't. The primary research for this episode is compiled from contemporary reporting, government records, Kentucky Attorney General decision, a federal civil rights report, and a published Kentucky appellate opinion. Antonio Orlando Sullivan was an 18-year-old black man living in Lexington. Contemporary reporting sometimes referred to him as Antonio Sullivan and sometimes as Tony Sullivan. Police said he was wanted on felony warrants for assault and one endangerment arising from an earlier shooting. Even the date of that alleged offense is unclear. Associated Press reports published immediately after Sullivan's death identified the earlier shooting as occurring on September 30th, 1994. A detailed Washington Post retrospective published in December 1995 said witnesses accused Sullivan of shooting a rival gang member on September 25th. Now, that may be the difference between the date on the incident and the date used in the warrant or police paperwork. Or one report may just simply be wrong. We do not know because the underlying arrest warrants and charging documents were never located during a public search. Police later associated Sullivan with a neighborhood group called the Hood. That description came from police and later news reporting. It was not established through any criminal trial located for this episode. Sullivan's juvenile records were confidential, and when WTVQ reporter Susan Parsons sought access to records after his death, the Fayette County Attorney's Office denied the request. On December 9th, 1994, the Kentucky Attorney General upheld the denial in Open Records Decision 94-ORD-147. The decision determined that the juvenile records remained protected and that certain investigative records held by the county attorney were permanently exempt from disclosure. And that means much of what police said about Sullivan's alleged history cannot now be independently checked against the original files. And I want to make one point very clear before we go any further. Tony Sullivan having warrants does not settle the question of how he died. A person can be suspected of a violent crime and still have the right to not be negligibly and intentionally shot while surrendering. An arrest warrant is permission to arrest someone. It is not permission to execute them. On October 25th, 1994, 5 Lexington Fayette Urban County police officers went into the residence of Sullivan's girlfriend or fiancée. Different reports use different descriptions of the relationship and describe the location as either a home or an apartment. A later Lexington history account placed the shooting at 726 Breckenridge Avenue in the Bluegrass Aspendale area. That address was not corroborated throughout the original police report, court filing, or dispatch record located in this investigation. So it is likely, but not conclusively, established as primary record. The 5-officer team included Sergeant Phil Vogel, 2 additional white officers, and 2 black officers. The other 4 officers have not been reliably identified in the accessible sources. We do not know where each officer was standing. We do not know which officer found Sullivan. We do not know who gave commands. We do not know whether every officer had a clear view of the shooting. We do not have their original statements. Phil Vogel was a white Lexington police sergeant with approximately 22 years on the department. The Washington Post later reported that he was around 48 years old in late 1995. Police Chief Larry Walsh described Vogel as an officer with no prior misconduct record and called him tactically sound. That was the chief's description. Vogel's complete personnel and internal affairs files were not located, so that claim cannot be independently verified. Vogel was carrying a 9mm semi-automatic Beretta pistol. The exact model, serial number, maintenance history, and inspection records are unavailable. Those missing records and details would later become extremely important. Now, according to reports, police entered the residence looking for Sullivan, and they found him hiding in a closet. Chief Walsh's initial public account says Sullivan did not respond to orders to come out and was shot as he stepped from the closet into the living room area. Later official summaries and retrospective reporting added more detail. They said that Sullivan emerged unarmed. They said his hands were raised. They said he was surrendering. And they said Sergeant Vogel was attempting to lower or decock the hammer on his pistol. During the process, the weapon discharged and the bullet struck Sullivan in the head. He died at the scene, and no accessible record provides the exact time officers entered the home, and we do not have the computer-aided dispatch log. We do not have the police radio traffic. We do not have the scene log. We do not have the exact time of the gunshot. We do not have emergency medical response timeline. We do not have the precise time Sullivan was declared dead. The fundamental sequence is supported by multiple accounts. Sullivan was in the closet. He emerged unarmed. His hands were reportedly raised. Vogel manipulated his handgun. The gun fired. Sullivan was shot in the head and killed. The unresolved question is why that gun fired. The police department's explanation came quickly. The shooting was an accident. Vogel said his pistol discharged while he was attempting to lower the hammer. Later, a U.S. Commission on Civil Rights report said Lexington police and Fayette County grand jury believed the weapon malfunction contributed. Now, these phrases may sound similar, but they do not necessarily mean the same thing. An accidental discharge only means the shooter claims the gun was not intentionally fired. It does not explain why it fired. A mechanical malfunction could mean something inside the firearm broke or failed. A negligent discharge could mean the officer touched the trigger, failed to control the hammer, pointed the muzzle in an unsafe direction, or violated basic weapon handling practices. A shooting can be unintentional and still be negligent. It can be unintentional and still violate departmental policy. It can be unintentional and still criminally reckless, depending on the evidence and applicable law. And that's where the missing records become the entire story. The public has never seen the firearms examination. We do not know whether the pistol was test fired. We do not know whether investigators recreated the decocking process. We do not know whether the weapon fired without the trigger being pulled. We do not know whether a safety mechanism failed. We do not know whether a hammer slipped. We have absolutely no idea where Vogel's trigger finger was positioned. We do not know whether the muzzle was pointed directly at Sullivan or whether the weapon moved during the manipulation. We do not know the bullet trajectory. We do not know the complete autopsy. We do not have photographs and diagrams of the room. We do not know the distance between Vogel and Sullivan. You noticing a pattern here? We do not know whether the other officers agreed with Vogel's description. The word accident became the final public conclusion without the public ever receiving the evidence required to evaluate it. That does not prove the shooting was intentional. It also does not prove Vogel was blameless. Those are separate questions. The official explanation was not the first version many of the people in the neighborhood heard. According to a contemporary AP reporting, Sullivan's fiancée said a babysitter inside the residence witnessed the shooting. The fiancée said the babysitter believes Sullivan was deliberately shot. A later LAX 18 retrospective also recalled an account that Sullivan's arms were raised and that he was unarmed. The original eyewitness statement is not publicly available, and here we go again, but we do not have a recorded interview, we do not have a signed statement, we do not have a grand jury testimony, and we do not know the witness's precise location inside the home. We do not know whether the witness could see Vogel's hands, his trigger finger, or the pistol's hammer. Because that original evidence is missing, it would be irresponsible to declare that the eyewitness conclusively proved an intentional shooting. But it would be equally irresponsible to erase the conflict completely. There is a competing version. That version spread outside the residence almost immediately. People in the neighborhood heard that Tony Sullivan had come out with his hands raised and was shot anyway. The official story said accident. The neighborhood story said deliberate shooting. And within hours, Lexington erupted. The shooting occurred during the day on October 25th. The Lexington Herald-Leader front page reported that young people began moving from Bluegrass Aspendale area toward downtown around 1 p.m. The exact number of participants depends on which report you read. The Herald-Leader described more than 100 young people. Associated Press reporting used an estimate of around 200. Other early reports described hundreds and gave numbers as high as 500. Those estimates may have counted different groups at different times. One number may describe the original march. Another may describe the peak downtown crowd. Another may include people gathering later in surrounding neighborhoods. I mean, as far as I'm aware, there's no official event log that was located that resolves the difference. What is clear is that large group moved towards downtown demanding answers. Around 30 young people reportedly entered or met with Chief Larry Walsh inside the Urban County Government Center. They wanted an explanation, and the meeting did not resolve the situation. Reporting says police officers carrying clubs escorted the group from the building. Outside, the demonstration became a mixture of protest, anger, property destruction, and violence. Windows were broken, vehicles were damaged, and according to some accounts, overturned. Rocks and bottles were thrown. People moved throughout parts of downtown. Businesses and government offices closed. Several police officers, civilians, and news media workers were injured. The injuries were described as non-fatal and generally not serious. By dark, much of the downtown crowd had dispersed. Police wearing riot gear guarded government and court buildings. Tensions continued in predominantly black neighborhoods. Later reports described additional clashes and attacks involving emergency vehicles. 5 people were eventually tried and convicted of rioting, according to the Federal Civil Rights Report. The research did not locate their names, exact charges, verdict dates, or sentences. On October 26, the day after Sullivan's death, an unmarked television news vehicle was struck by gunfire. No one inside the vehicle was reported injured. That incident became part of the continuing coverage of unrest and neighborhood tension. It is important not to merge every act of violence into one organized conspiracy. The available reporting does not establish who fired at the vehicle or whether that person had participated in the original downtown protest. It does demonstrate how unstable the situation remained. A police shooting had triggered anger, and the anger had continued into confrontations and destruction, and Lexington was now receiving national attention. The FBI joined the investigation on October 26th. V. David Cole, then the FBI's senior agent in Kentucky, said agents would examine whether Sullivan had been subjected to police brutality. Later accounts stated that the FBI or Justice Department investigation concluded the shooting was accidental. The U.S. Commission on Civil Rights Kentucky Advisory Committee reported that 3 separate bodies investigated: the Lexington Police Department, the Fayette County Grand Jury, and the FBI. The commission said all 3 concluded that the shooting resulted from an accidental discharge. But the federal investigation is known almost entirely from summaries. No publicly accessible FBI closing report was located. No agent interview memoranda were located. No federal firearms analysis was located. No Department of Justice Civil Rights declination letter was located. No memorandum explaining the applicable federal law was located. We know what federal law conclusion supposedly was. We do not have the federal evidence or reasoning behind it. That is a recurring problem with this case. We have conclusions without the files that support them. On Wednesday, October 26, 1994, the Lexington Herald-Leader gave the story dominant front page coverage. The huge headline read, "Killing of Teen Sets Off Rampage." The subheadline read, "Police Say Shooting by Officer Was Accident." That choice of word matters. The largest headline focused on the crowd. The police shooting was placed underneath and introduced through the official police explanation. The newspaper's main photograph showed police confronting young people. A caption identified Sergeant James Turley facing youths at 4th Street and Hawkins Avenue as they returned from Government Center protest. Turley was involved in the response to the disturbance. Nothing in this accessible record establishes that Turley was one of the 5 officers present when Sullivan was shot. He should not be confused with Phil Vogel or the arrest team. The newspaper package devoted major attention to broken windows, injuries, arrests, and angry young people moving through downtown. those events were real. But the layout and wording shaped what readers saw as the primary crisis. The front page did not scream unarmed teen shot in the head while surrendering. It screamed killing of teens. Teen sets off rampage. The disturbance became the main subject. The police explanation became the supporting detail. National wire coverage used similar racialized language. A Los Angeles Times headline read, "Blacks take the street after police killing." A later report referred to rampage by 200 blacks. That was common language in portion of the 1990s crime reporting, but common does not mean neutral. It collapsed a crowd of individuals into one racial category. It centered public disorder, and it encouraged readers to view the community primarily as a threat rather than as people reacting to the disputed police killing. Some reports did preserve the compelling account. The October 26 Associated Press story carried by Washington Post reported both the police claim of accidental discharge and the fiance's report that the babysitter believed the shooting was deliberate. That is one of the earliest pieces of coverage that placed both narratives together. The events of October 25th did not come out of nowhere. 2 years earlier, in 1992, a civil rights briefing had examined race and policing in Lexington. Police Chief Larry Walsh told the gathering that Bluegrass Aspendale generated approximately 13,000 calls for police service during a 12-month period. Residents complained that their neighborhood was not receiving the same rigorous police protection as other parts of Lexington. The department responded with intensified patrols, anti-gang enforcement, youth initiatives, and a partnership with the housing authority. But some residents said the increased police presence made them feel watched, controlled, and treated as suspects. Lexington businessman Shahid Rashid challenged the official presentation of race relations. He warned leaders against glossing over the underlying problems. Those positions are not contradictory. A neighborhood can demand protection from crime and still distrust the police. Residents can want violent offenders arrested and still object to aggressive and unequal enforcement. People can ask for faster police response while also demanding that officers be held accountable when someone dies. The later U.S. Commission on Civil Rights report describes sharp racial inequalities in Fayette County. Black families were reported to be more than 5 times as likely as white families to live in poverty. The figure cited 32.1% of black families compared to 6.7% of white families. Black residents were also less likely to own homes, 35.6% compared to 55.9% for white residents. The report discussed additional disparities involving education and property values. At the 1992 briefing, then Mayor Scotty Beasler said that he did not believe Lexington suffered from serious racial hostility. He acknowledged occasional flare-ups and pointed to race relations efforts, public housing investment, youth programs, and prejudice reduction work. 2 years later, Tony Sullivan's death exposed just how wide the gap was between the city's institutional self-image and the distrust expressed by many black residents. Lexington officials argued that the department was making efforts to address racial concerns. The police force reportedly had approximately the same black representation as the city's black population. Around 12% of the 409-member department was black. 2 black officers were included in the 5-officer team sent to arrest Sullivan. Those details complicate the racial discussion. They do not end it. A department can employ black officers and still have policies, tactics, or accountability systems that black residents distrust. Representation does not automatically prove equal treatment. It does not explain why a gun was pointed toward an unarmed person. And it does not make hidden records transparent. Policing tactics in Lexington were also changing during this period. Walsh said the department had historically neglected predominantly black neighborhoods and had introduced foot patrols and anti-gang enforcement in response to demands for more protection. The Washington Post reported that crack-related arrests increased from 4 in 1992 to 399 in 1994. Police associated Sullivan with a group called the Hood. And again, those claims came largely from police. The unavailable juvenile and criminal files prevent any independent evaluation of Sullivan's alleged role or the evidence used to label him as gang-affiliated. A report in the police trade publication Law Enforcement News stated that the Fayette County Coroner's Office ruled Sullivan's death unintentional on January 9, 1995. The original coroner's report was not located. The complete autopsy was not located. Toxicology findings were not located. Wound path analysis was not located. The formal death certificate language was not located. We therefore know the reported classification. We do not have the medical evidence used to reach it. A coroner's classification of unintentional concerns the manner of death. It does not automatically answer whether an officer violated policy or negligently handled a weapon. Those are administrative, civil, and potentially criminal questions. On February 2, 1995, a Fayette County grand jury declined to indict Phil Vogel. That means the grand jury did not return a criminal charge. It does not mean a public trial occurred. It does not mean the evidence was tested through cross-examination. It does not mean the public learned what the witnesses said. Kentucky grand jury proceedings are secret. The transcript was not released. The exhibits were not released. We do not know precisely what prosecutors presented. We do not know how the firearm was described. We do not know what legal instructions were given. We don't know whether the babysitter testified. We don't know whether the other officers' accounts were consistent. We don't know the grand jury's vote. A community organization later sought access to the grand jury transcript and requested a public counsel hearing. Officials reportedly considered further review unnecessary because 3 investigations had already reached the same conclusion. But 3 agencies repeating the same conclusion is certainly not the same as 3 transparent investigations. A 2014 blog post about Vogel later reproduced what it described as a passage from a 1995 New York Times article, claiming the grand jury contained 11 white members and 1 black member. The original Times article was not independently located during the research used for this episode, so that specific racial breakdown should be treated as secondary reporting rather than primary verified fact. Phil Vogel left the Lexington Police Department at approximately the same time the no indictment decision was announced. Sources disagree on what to call his departure. The Federal Civil Rights Report and later Lexington accounts called it a retirement. The Washington Post called it a resignation. The formal personnel order was not located, but all accounts agree that Vogel was gone from the department around the time the grand jury cleared him criminally. And there is another important detail. The Washington Post reported that Lexington planned to pursue departmental disciplinary charges against Vogel. Those charges became moot when he left. That raises an obvious question. If the shooting was nothing more than an unavoidable mechanical accident, why was the department preparing discipline? Maybe the proposed charge involved unsafe gun handling, maybe a policy violation, maybe investigators believe Vogel made a tactical mistake. Maybe it involves something else entirely. We do not know. Obviously, the administrative investigation was not located. The proposed charges were not located. No final disciplinary findings were ever issued because Vogel's departure ended the process. A lack of criminal indictment does not mean there was no administrative misconduct. The city's own reported plans suggest officials believe some form of discipline might have been justified, but the public was never shown these details. In November 1995, Sullivan's mother reportedly filed civil negligence actions against Vogel and the Urban County government. The original complaint was not located during this research. No discovery records were located, no deposition transcripts, no court order resolving liability was located. But a later Kentucky Court of Appeals opinion establishes that a wrongful death settlement existed. The appellate case was decided on August 6, 1999. It did not decide whether Vogel or the city was legally responsible for Sullivan's death. Instead, it involved paternity claims against Sullivan's estate. Two mothers sought to establish that Sullivan was the biological father of their children so the children might share in the wrongful death settlement. The Fayette County District Court found that the settlement existed and that one or both children might be entitled to a portion if paternity were established. The courts ultimately ruled that Fayette County attorney lacked standing to pursue those particular posthumous paternity actions under the statute being used. The Court of Appeals explained that other legal procedures remained available to determine paternity and rights to the settlement. The opinion confirms the settlement. It does not reveal the amount. It does not identify every paying defendant. It does not state whether the city admitted wrongdoing. There is no disclose of release terms. It does not disclose confidentiality provisions. It does not explain how the money was allocated. The existence of a settlement does not prove criminal guilt. Cities settle lawsuits for many reasons, but it does establish that Sullivan's death produced a civil resolution involving money, even though the public cannot see the terms. Here is the strongest version of the official narrative. 5 officers entered the home to serve felony warrants. Sullivan hid inside a closet. He emerged unarmed with his hands raised. Sergeant Vogel attempted to decock his pistol. A malfunction or accidental discharge occurred. The bullet struck Sullivan in the head. Police investigated. The FBI investigated. A grand jury reviewed the case. The coroner classified the death as unintentional. The grand jury declined to indict, and that is the official story. Here is what that narrative does not establish publicly. Whether the pistol had a genuine mechanical defect, whether Vogel touched the trigger, whether Vogel followed Beretta's decocking procedure, whether the firearm had a functioning decocking lever or required manual hammer manipulation, whether the muzzle was pointed at Sullivan throughout the process, whether the departmental policy allowed an officer to decock the weapon while covering a surrendering suspect, whether the gun had a prior maintenance problem, whether Vogel had been trained on the specific weapon, whether another officer warned him, whether the eyewitness saw the critical moment clearly, whether every officer gave the same account, whether investigators tested alternative explanations. The official conclusion may be correct. The public record is not complete enough to independently prove that it is. There are at least 3 broad possibilities. First, the firearm suffered an unforeseeable mechanical failure that Vogel could not reasonably have prevented. Second, the shooting was unintentional but resulted from unsafe weapon handling, poor muzzle control, trigger contact, inadequate training, or negligence. Third, the shot was intentionally fired and the accident explanation was false. The accessible evidence does not allow us to responsibly select the third possibility as fact. The original eyewitness evidence is missing, the physical evidence is missing, and the firearms examination is missing. But the available record also does not allow anyone outside the investigation to confidently distinguish between the first and second possibilities. That distinction matters. Calling something an accident can become a way of making responsibility disappear. If I drive recklessly, run a red light, and kill somebody, the collision may not have been intentional. That does not mean my conduct was blameless. If a trained police sergeant manipulates a loaded weapon while the muzzle is pointed toward an unarmed, surrendering teenager, the fact that he may not have intended to fire does not automatically end the accountability discussion. Intent is only one part of responsibility. More than 30 years later, these records remain unavailable in the accessible public record reviewed for this episode. The Lexington Police Report, the arrest team report, the computer-aided dispatch logs, police radio recordings or transcripts, scene entry and evidence logs, statements from the other 4 officers, the original eyewitness statement, the internal affairs investigation, the administrative investigation, the proposed disciplinary charges, the firearms examination, the pistol's maintenance records, the exact Beretta model and serial number, the autopsy report, toxicology, wound trajectory and distance analysis, that's a rough one to say, the coroner's complete file, grand jury transcripts, grand jury exhibits, the FBI investigation file, the Justice Department closing or declination of memorandum, the civil complaint, civil depositions, the settlement agreement, the payment amount, the identity, charges, and sentences of the 5 people reportedly convicted of rioting, Vogel's complete personnel and disciplinary history. Without those records, a second-by-second reconstruction is impossible. We do not know Sullivan's exact words. We do not know Vogel's exact words. We do not know the officers' positions. We do not know the pistol's condition. We do not know the precise muzzle direction. We do not know whether Vogel's finger contacted the trigger. We do not know what the city intended to discipline him for. That is not a minor information gap. That is nearly everything required to evaluate the official explanation of it being an accident. Nearly 20 years after Tony Sullivan's death, Phil Vogel appeared in another story that was so bizarre it sounds fictional. By 2014, Vogel and his wife Rose Marie Vogel were living in Arizona. Phil Vogel was hospitalized at Chandler Regional Medical Center after undergoing heart procedure. Hospital employees say they saw Rose Marie Vogel tampering with his IV line. A brown substance was discovered inside the tubing. A laboratory identified it as fecal matter. Police searched Rose Marie Vogel's purse and reported finding 3 syringes. One reportedly had traces of a brown substance. Rose Marie Vogel was a retired registered nurse who had previously worked at that hospital. She was arrested and initially accused of an attempted first-degree murder and abuse of a vulnerable adult. Phil Vogel became ill but survived. The initial attempted murder allegation was not her final conviction. Rose Marie Vogel later pleaded guilty to vulnerable adult abuse under an agreement that dismissed the attempted murder charge. In December 2014, she was sentenced to 1 year in jail. The judge permitted her to serve the jail time on weekends. She also received 4 years of probation. She surrendered her nursing license, and at sentencing, she said she had been sleep deprived and depressed and claimed she did not remember contaminating the line. Phil Vogel told the court he had forgiven his wife and did not believe she remained a danger to him. Now, before anybody turns that into some cosmic karma nonsense, let's be responsible. What happened to Phil Vogel in Arizona does not prove anything about what happened inside that Lexington home in 1994. His wife's crime does not make him guilty of intentionally killing Tony Sullivan. It does not alter the physical evidence. It does not fill in the missing police reports. It does not prove the original shooting was murder. It is relevant only as a documented and extremely strange later chapter in the life of an officer who shot Sullivan. Nothing more, nothing less. Now, what we can say with high confidence is that Tony Sullivan was an 18-year-old black man. He was unarmed when he was shot. He had been hiding in a closet. 5 Lexington officers were inside the residence. Sergeant Phil Vogel fired the fatal shot. The bullet struck Sullivan in the head. Vogel was a white 22-year police veteran. A grand jury declined to indict him. He left the police department at around the same time. A wrongful death settlement eventually existed. We can say that with moderate confidence that Sullivan had his hands raised, that Vogel was attempting to decock the pistol, that official investigators believe a malfunction contributed, and that the federal investigation concluded that discharge was accidental. Those details appear in credible later accounts, but the underlying evidence is unavailable. We cannot say with confidence exactly where Vogel's finger was, exactly where the muzzle was pointed, whether the pistol truly malfunctioned, whether Vogel improperly handled it, whether the babysitter's account was fully accurate, whether the shot was intentional, what disciplinary charge the city planned, or how much Lexington ultimately paid. That is the responsible line. Anything beyond that is speculation. And on that note, we come to my opinion section. Now, my opinion really doesn't matter to anyone but me. But these are my podcasts, so I'm going to add it. I don't think you can really go through the research, what little is actually available for this case, without actually acknowledging the racial aspect of it, because you just can't get around it. I mean, how many of you had actually heard of riots in Lexington? Because I'll tell you what, I have talked to multiple people who have lived here their entire life who had no idea about this case, had no idea about marching all the way downtown and what they called riots. And then again, I put out a post that I was going to make this episode, and I have had family, I've had everybody in the comments. If you notice, I haven't answered anybody for a very specific reason. I wanted to make the episode, and then we can go back and start answering questions. I've been everything from forever invited to the barbecue to I'm a racist for bringing this up. This is a fairly, important lesson in the city of Lexington, and I'm not the only one that feels like it's just swept under the rug. That nobody needs to know about this. Move on. Nothing to see here. And obviously, I mean no disrespect to any of the family members, the friends. I've seen in the comments he had a whole lot of people that cared for him greatly. T-Love. And I don't care what your history is, what your past is. I don't care what kind of warrant they are serving on you. You don't deserve to be murdered in the process of surrendering with your hands up. Like, they can claim accidental discharge, they can claim malfunction. I've got people in the comments who claim, well, nobody talks about how his hand was injured, it's because the evidence has been suppressed. We don't know about that. I can search that right now, and you cannot find that. Trust me, I've went as deep as I can without requesting every record from every department, and if it goes to that point, we can try it again. They're going to decline it. But in my opinion, that could not be the very first time that man handled the gun. I try not to cuss on here. I'm sorry about did. A 22-year veteran of the Lexington Police Department. I mean, if it was some rookie who had just shown up last month and was green under the collar, whatever, that'd be far more understandable. But it does not look good that a 22-year veteran of the police force, a sergeant, decocking his gun and there was a malfunction, it just comes off as a convenient excuse to me. Now, if it was easily provable, I think they would have released all the paperwork, the reports. To me, it seems like the thin blue line covering for the thin blue line all the way up to the FBI. And of course, those are opinions. Opinions are like buttholes. Some of them stink. But we all got them. With that being said, though, Tony Sullivan was not killed in a dark alley by an unknown person. The shooter was known. The weapon was known. The officers were known to investigators. The scene was controlled by police. Local police investigated. Federal agents investigated. A grand jury reviewed the case. The city considered discipline. A lawsuit was filed. A settlement was reached. And somehow, 30 years later, the public still does not have enough evidence to independently understand why a veteran police officer's gun fired into the head of an unarmed teenager whose hands were reportedly raised. Lexington officials could point to 3 investigations. The community could point to an eyewitness who said the shooting was deliberate. The newspaper could point to broken windows and call it a rampage. The grand jury could decline to indict. The officers could retire or resign. The city could settle, but none of those things answer the simplest questions. Why was a loaded pistol being manipulated by pointed toward Tony Sullivan? Maybe it was a freak mechanical malfunction. Maybe it was negligent gun handling. Maybe critical evidence supported Vogel's explanation. But when evidence stays hidden, officials are asked the public to trust the same system that investigated itself. And trust is exactly what Lexington did not have in October 1994. Tony Sullivan had warrants. He hid from the police. He may have been accused of serious crimes. He was also unarmed. He was also reportedly surrendering. And he did not deserve to be shot in the head because a trained police sergeant could not safely control his weapon. That's true whether the shot was intentional or accidental. The shooting was officially classified as unintentional. The criminal case was officially closed, but officially closed does not mean publicly explained. This has been a special crossover episode of WTF, trying to keep it clean, and Buried in Bluegrass. 2 shows, 1 Kentucky story, and questions Lexington still has not answered. I'm old Gerg. Stay loud, stay skeptical, and I'll see you on the next one. This episode is based on contemporary AP coverage, the October 26, 1994 Lexington Herald-Leader front page, Washington Post reporting, the U.S. Commission on Civil Rights report, Bias and Bigotry in Kentucky, Kentucky Attorney General Decision 94-ORD-147, the Kentucky Court of Appeals decision involving Tony Sullivan's estate, later Lexington news retrospectives, and reporting concerning Phil Vogel's later life. Where sources conflict, those conflicts have been identified. Claims about eyewitness account, Sullivan's alleged gangs association, the weapon malfunction, and Vogel's employment departure are attributed to their sources rather than presented as independently proven facts. The underlying police, forensics, grand jury, and federal investigation files needed to independently reconstruct the shooting were not located. This podcast is a proud member of the OGM Podcast Network. You can follow us on Facebook,